Let's dive into a high-stakes legal battle. It's about snack food, of all things, but it's also about a huge corporation's intellectual property. And believe it or not, the entire multi-million-dollar dispute came down to the legal meaning of a single two-letter word, two.
So get this. The case revolves around a patent for making the perfect snack. But according to expert testimony, if you actually followed the patent's instructions as they were written, you wouldn't get a delicious snack. You'd get a charcoal briquette, something completely burnt, inedible, incinerate.
So the big question is, how on earth did this happen? How could a patent, which is supposed to protect a brilliant invention, be legally interpreted in a way that describes its total destruction? Well, that's what we're going to break down in the case of Chef America versus Lamb-Weston.
All right, to really understand what's going on here, we have to start with the invention itself. It all began with a simple goal, creating the perfect texture for a frozen snack. The company, Chef America, had what was called the 290 patent, and it was designed to solve a problem we've all experienced, right? You microwave a frozen snack, and it comes out soggy or tough. This patent laid out a process that was supposed to guarantee a light, flaky, and crispy result every single time. The process had a few key steps, but it's that third step that became the whole problem: a quick heating of the batter-coated dough. See, this step was meant to create tiny pinholes that would help it cook fast later on. That was the secret to getting it crispy. And this specific step is where the entire legal fight was centered.
And that brings us to the exact point of the legal fight. The whole lawsuit, the appeal, everything, it all boiled down to how you interpret one simple word in the description of that heating step.
The patent said the dough should be heated to a temperature in the range of about 400 degrees Fahrenheit to 850 degrees Fahrenheit. So, here's the debate. Does that mean you set the oven to 400 degrees? Or does it mean the dough itself has to reach an internal temperature of 400 degrees? I mean, the difference there is just massive. So when this first went to court, the district court had to make a call. And they decided that 2 meant the dough's internal temperature had to get that high. Since Lamb-Weston could prove their process didn't do that, the court said they weren't infringing the patent. Just like that, Chef America's case was thrown out, which of course led to an appeal. So the case moves up to the U.S. Court of Appeals for the Federal Circuit. This is the top court for all patent appeals. And the arguments they heard really set up this amazing conflict between, practical, real-world common sense and just the literal black and white text on the page. Chef America's argument was all about reality. They were basically saying, come on, judges, use your common sense. Heating dough to 400 degrees internally would just destroy it. That's an absurd result. They wanted the court to read to as if it meant at. But Lamb-Weston came back with a very strict, very literal argument. They said, look, the patent says chew. It's not the court's job to go back and rewrite a patent just because the inventor made a mistake. So, how did the Federal Circuit, the highest patent court in the United States, resolve this clash between reality and the written word? While the court sided completely with Lamb-Weston, it upheld the lower court's decision, saying that the language was clear. The dough itself had to be heated to that 400 to 850 degree range. Chef America's appeal was denied. The word to was interpreted literally, even if that meant the patent was for a process to create charcoal. And this quote from their decision really sums up their whole philosophy. The court was incredibly firm on this point. They said that it's not their job to redraft a patent claim, not even to fix a mistake that seems obvious, and not even to make the invention actually work. The court's logic was really methodical, and it came down to 3 key points. First, the plain ordinary meaning of the words. In everyday English, heating something to a temperature means the object itself gets that hot. Simple as that. Second, the fundamental role of a judge is to interpret the law as it's written, not to act as an editor and fix what they think should have been written. And third, and this is the real kicker, they looked at the patent's prosecution history. The inventors had actually used the word at in other parts of the patent application, but for the specific, crucial claim, they chose the word to. That suggested it was a deliberate choice, not just a typo. So let's zoom out a little bit and think about the wider implications here. What's the big lesson from this case about law, language, and bringing new ideals into the world? Why this case is so important is that it serves as this really powerful and, frankly, pretty harsh reminder that when it comes to patent law, every single word matters. The court sent a clear message. We will not step in to save you from your own mistakes. The words you choose are the words you're stuck with. If there's one thing to take away from all of this, it's this. A patent doesn't protect the brilliant idea you have in your head.
It protects the specific words you use to write that idea down on paper. At the end of the day, your patent protects what the words literally say, not what you wished they would say.
And that leaves us with one final thought. Chef America set out to patent a recipe for a perfect snack, but they ended up with a federal court confirming that they owned a patent describing how to make a charcoal briquette. It just makes you wonder, doesn't it? How many other huge multi-million-dollar outcomes in contracts, in laws, in other patents are just hiding there in plain sight inside a single, seemingly insignificant word?